Okay, so hopefully everybody can see a slide that says adult guardianship, a flight path through the first 90 days. Just one person can confirm that.
Confirmed.
Jim, can you see it? Thank you.
Yes,
Okay,
we can.
so uh, I'm here co-presenting with Jim Bates of Puget Sound Estate Solutions. I'm Liz Johnson of Liz Ann Johnson Elder Law. Jim has been an attorney for a very long time, since at least 1997, but he didn't start practicing here in Washington until 2014. He is a private pilot, so if we want to play a guessing game later about why we named our slides the way we did, we can. He is also a published author on legal aviation and scale modeling topics. Outside of work, he enjoys exploring museums, parks, and libraries, and spending time in the Puget Sound with his stepdaughter. My practice area generally focuses on probates, wills, trusts, estate planning, long-term care, obviously a lot of guardianship. Jim and I are both court visitors. Jim is co-chair of the Guardianship Committee currently and also helps run the Court Visitor Mentorship Program. So that's our area of expertise and why we will be pitching all of you to join this area and be appointed as as respondent attorneys, as court visitors, and as guardian attorneys all throughout this process. If you're not an attorney, this is also really helpful to you because I would say that there's a lot of effort putting into getting somebody appointed as a guardian conservator, but then the next 90 days to a year can often be a bit of a mystery. There are a few things that you want to do at the appointment hearing. One, you want to make sure you've read the order and you understand what authority you were given and what jobs you were given. There are a variety of different types of guardianship and conservatorship. They could be full or limited, or you might just be a guardian, or you might just be a conservator. And for fun, because everybody loves reading rules and orders, sometimes it says you have these duties if there's no guardian appointed. If there's no guardian appointed, you also have these duties. And same thing for conservators. So you have to pay attention to what jobs you were given and what authority you do have. Generally, that order appointing someone goes to the clerk's office, and that's where you go to get a copy of it. If you are given the original order at court, you want to make sure you walk it directly down to the clerk's office. Don't go to the elevators, don't leave the building. Otherwise, you're going to have to come back and get a new order and tell the judge that you wandered off with their order. You don't want to do that. From this order appointing, in addition to reading it thoroughly and making sure you've read perhaps the court visitor report, have a thorough understanding of what the visitor recommended and how they arrived at some of their decisions, you want to keep track of several things: your date of appointment, whether you're full or limited guardian, and if or conservator. And if there's a bond requirement, that's one of the first things that you're going to have to take care of to get your letters. Even though you have an order and some places will ask for the order, more often than not, your letters of guardianship or conservatorship are sort of the gateway. DSHS is going to want to see them, banks will want to see them. Most people will want to see that letter of guardianship that comes on special paper and is stamped by the clerk's office. Generally, people won't accept copies of it. You'll need certified copies. To get that letter, you have to have done your oath, your acceptance, and if there is a bond, you have to go get the bond. So you get the order appointing, you fax it over to some bonding company, they send you over a bond, you have to get the judge or commissioner to sign that bond. Then once that's entered, you can go get your letters of guardianship. Sometimes the courts will leave on a 120 review if you've been appointed guardian or conservator, but also a lot of times they'll make it your next hearing date, which is a year and 90 to 120 days in the future. You still have to do your 90-day report, which means that within 90 days of being appointed, there is a plan and or an inventory due. There is also, you have to have hearings on those documents and they have to be on file for a certain period of time before you can ask for approval of them. So when we're working with some people who maybe are not as familiar with the law, they often start working the case at 90 days, which is a bad time to start doing it. It can take a long time to get access, even once you've had the orders and the letters of guardianship, to get access to a lot of the accounts or to be put on as the contact person. It can take several months, even if you go to the Social Security office, to become the representative payee. under this document. So you want to make sure that in that first 90 days, especially the first even week, you're running around trying to get everything taken care of so that they're sending your orders and your letters off and they're getting them to the right people because they may have to go to back offices or legal departments or wherever within the different organizations to get you switched over and put onto all of the accounts. So the reason that you get roughly 90 days is not so that you have a leisurely 90 days to work on this whenever you want. It's because it legitimately can take 90 days or more. For some investment accounts or high value accounts, it can take even longer than 90 days to get put on them. You also want to pay attention to your annual report and when your letters expire. This is all important information that comes in on your initial order appointing. Your report dates are going to run from appointment until the end of an accounting period. So you want to make sure you align your documents and your paperwork that way. If you start off doing it correctly, then it's much easier when you get the annual report. And regardless of if you're an attorney or you're the guardian or you don't have an attorney, it is very, very important to note that you are not doing the court a favor. You are being appointed to do a job, which means you have a fiduciary duty. So it's very difficult to come back in a year and 90 days and tell the judge, well, I didn't keep any receipts, or I didn't know I had to do a 90-day report. I went to the clerk's office and they didn't tell me. It is always the guardian conservator's job to make sure that their job is done correctly. And the clerk and legal professionals at the courthouse aren't able to give you legal advice, which always feels a little bit funny because you can go in and say, what is due next? And they're like, we can't tell you, read the rules. But then when you don't have it and you go in, they're like, you don't have your 90-day report. And you're like, you're still telling me a little bit what to do, but now you're just telling me I'm late to do it. So you have to be really careful. You can't go to the clerk's office and say, is anything due or what do I have to do next? They won't know. And if you just listen to that because they say, well, I don't, the next hearing is in a year and 120 days. If you ignore your 90-day stuff, then you're not going to be in compliance by the time you get to your hearing. Um, so I did kind of go into this part already. So making sure that you've read the entire flight plan and that you understand all of the information that you're supposed to do and understanding that it is your job as the guardian conservator to get it done. Attorneys should be advising their clients and reminding them. If you are an attorney or even if you're not, I typically remind people at the close of the accounting period because that gives them 3 months to get everything in order, even though I know it won't be ready when I send the reminder. I also send the last report if there is one, just so they remember where we're starting off so we can have a good starting and ending number. And it's really important to understand and read about what is the requirement for an accounting or an inventory or a 90-day. Some people get very prolific, and a judge and a commissioner don't really have time to read a 90-page report like they're looking to the guardian conservator to provide them the information they need. But you also want to provide enough information that the commissioner or judge understands what's happening with your client. For financial stuff, you want to save receipts and balance your checkbook. I don't want to take a poll to see how many people balance a checkbook because I've been saying that phrase a lot, and a lot of people look at me like, balance your checkbook? Like on your finger? Like a book on your head? It's like, no, you grab the bank statement, you check off everything that's on there, and you make sure the beginning and end balance matches what you've spent. Another thing that's important when you get appointed is to remember that this is a fiduciary duty. Never say that you're doing anyone a favor. Even if you're doing this job for free, it's still not a favor. It's a job that you agreed to accept. So you do have to keep your accounting correct. You should not be spending cash out of someone's account. You definitely can't be commingling it. So you want to make sure you start with the end in sight and you know how to get through the process. Oops, that went through a little fast. So once you get appointed, again, we talked about filing the acceptance of appointment. There is also a disclosure of a guardian conservator. There's a Form M for lay guardians and a Form N for certified guardians, or I got those backwards, but there's a form for each person. If you didn't file those prior to appointment, you do want to make sure that you put that information on file for the court. Jim is going to show you a link to all of the different forms that are available at the end of the presentation, and you should also get that. Another thing to look out for is the bond requirement. There is, and then we didn't mention it, but there's also another thing that says in-state resident agent. So if you're a guardian or conservator who does not live in the state of Washington, if you are appointed, you do have to designate an in-state agent for service. So if that is in your order, then you'll want to make sure you do that as well. You also want to make sure that your bond is adequate and appropriate. So when you're reviewing the order appointing you, there is a formula in the statute that tells you how much bond you need to have, and you want to make sure that you do have that bond amount. There are also you want to make sure that the bond names the right people as the surety. So make sure that you understand who should be named on the bond. And you also want to make sure that the bonding company and you are jointly and severally liable. So you want to look through the bond requirements and make sure that the bonding agency that you pick is going to issue the bond in the correct manner, because it may not be clear. Make sure you read through the bond when you get it. Make sure it matches everything that you think it should. I have had bond companies issue bonds in the wrong name or in the wrong amount or for the wrong time period, in the wrong case number. So again, as the guardian conservator, it is your job to make sure it's correct. As an attorney, obviously, we should look it over as well to make sure that it's correct. Which is another reason you want to make sure that you have spent time reviewing the order appointing, because maybe you got more duties than you agreed to, or maybe you got less. And if the order appointing is not correct, it's harder to fix it. It's easier if you review it ahead of time and let whoever know prepared it, or if you prepared it, to make the corrections to it so you have everything you need. The next step is going to be blocked accounts instead of or in conjunction with bonds. And my esteemed colleague, Jim Bates, is going to take over from here.
All right. I'm going to back up a little bit just because we have some questions in the chat about what is a guardianship or conservatorship. Our intent here was talking about what happens once you're appointed, but let's just go back, since we have a few minutes, and look at this. So the statute that covers all of this is 11-130. And generally, the simple way to look at this is, in the past, our law had guardianship of the person, which is basically medical decisions, things like that, and guardianship of the estate, which is money. Well, 11-130 changed that, and our terms now are guardianship used to be guardian of the person, and conservatorship are what used to be guardian of the estate. And apparently I need to get my screen here to get the PowerPoint. Which might be beyond my ability. So what's happening here is you have a situation where somebody has some issues and a petition is filed. And in order to do that, there's a long petition. You can look on Washington courts. It's pretty straightforward. And at that point, a petition is filed, a court visitor is appointed. And I'm going to turn my screen off for a second, and hopefully when I come back, I'll keep talking. In this situation, you have a petition filed, and then a couple different parties may be appointed. The most immediate one is a court visitor. So when you go in with your order, a court visitor will be appointed. No, it is not a person from another universe. It is basically what we used to call a guardian ad litem. So they're the person who is going to, I'm having some interesting technical things here. That is the person that is going to investigate. Basically, court investigator would have been a better name. If the individual requests, an attorney may be appointed. In other counties, King, for example, they automatically appoint an attorney for everybody. Oh, well, that's not true. They often appoint an attorney. Can you guys still hear me? Because my computer's gone completely crazy.
Yes, James, we can still hear you.
Okay, I'll keep talking. I don't know what I'm talking about. So what we are looking at here today is, after this has all happened, the petition has been filed, the visitor has done their job, and the individual has been deemed lacking capacity to make decisions. Then at that point, I guess I can't do that. We are trying to get my screen to show your PowerPoint, and it is not working. It is fighting with all my two monitors, is what the problem is right now, just so you can know what's happening behind. As soon as I get my monitor back and I can see what I'm doing, there are...
James, may I interject?
30.
Would you like me to share it?
Yes, that would be great.
Okay, I'll be right back. Let me share it real quick. Hold on a moment.
Okay, so I'm going to give up on this, on the PowerPoint, and just talk about guardianship a little bit more. I think we need to play it. Oh, you're trying to get it on my screen. That's what's trying to happen here. Okay, I would say give up at this point, and I'm just going to, oh, is that working now?
No, it's not. You can turn your camera back on though,
Okay.
and I'm going to start sharing my screen.
We got it. It's working, I think.
Okay.
All right. Excellent. Awesome. So let me turn my video back on. All right, maybe I can't do that. I don't have that power anymore. There we go. All right. Unfortunately, I am back, and now we have a screen. So if I can get out of this, what I wanted to give everybody before I get into blocked accounts is there's a 3-part standard to appoint a guardian. The first one is there has to be some disability. The second one I'm going to not read because I don't have it in front of me, but it is there needs to be some inability to make decisions, inability to handle your money, things like that. And the third one is there can't be a lesser restrictive alternative. So before we go back to this, I'm going to take 1 second to talk about lesser restrictive alternative, which is quite simply, can somebody do a power of attorney? Are there other protective arrangements can be done? Because what the legislature has said is we want guardianship to be a last resort. All right, so that's a little bit of an intro of what guardianship is. Now let's go back to blocked accounts. So this gets interesting. As Ms. Johnson said, there is a situation where you've got to have a bond and or a blocked account. Generally, what I try to do is I try to keep the amount bonded being the amount I'm going to need for the guardianship for the year. And then everything above that goes into a blocked account. So basically, the blocked account is almost like the savings, and the bonded money is the money you're going to spend. I have heard some stories of people who do rolling orders. I'm a little uncomfortable with that. One of the things, the longer I'm doing this, the more and more uncomfortable I'm getting is we want this money protected. And it doesn't matter if it's 50 grand or 100 grand or $18 million. This is all the money the individual has. I was at the Guardianship CLE and Rob Nettleton, who's another attorney who does this, and Arlene Joe, who I think I saw her name here, who might be here today. We're talking about a situation where gentlemen had somewhere around $20,000 or $30,000. That was all his money, and the people ran off with it. And luckily, there was a bond for $20,000 or $30,000. So what I always try to make sure is we've got enough bond to cover the money. I actually grew up in a different legal world, and I'm kind of amazed that we get away with such small bonds in Washington. I was used to bonds that were like 2.5 times or 1.5 times the value of the property, rather than we've got $50,000 in the unblocked account, we're going to get a $50,000 bond. As Ms. Johnson said more than once, you are a fiduciary. This is not your money. Do not help yourself, and this is more for your guardians. Do not help yourself to the money. Do not borrow the money. This is somebody else's money. Keep it separate. Use it for what it needs to be done for. And absolutely 100% do not use it for another reason. You cannot continue to just use the person's account. You do need to open guardianship accounts. If they are blocked, there's going to be some forms for that. And that may be interesting. Try to educate your bank of what a blocked account is. That can be sometimes a problem. If it is a problem, reach out to us and we'll give you some institutions that actually understand what's going on. Okay, so let's talk about what are your duties. So you've been appointed, you got all your paperwork, you've got your bond, you've got your beautiful blue letters. I won't show you what these actually say, but beautiful blue letters. So one of the things I like about Pierce County, that they're on a different color. I don't think it's magic paper, but maybe it is. What do you need to do? So question number one, are you appointed conservator or are you appointed guardian? So if you are appointed conservator, then at that point, and going back to the bond and blocking, that's generally only going to be in a conservatorship situation. If you have a guardianship and all you are doing is making medical decisions and helping the person out, you're generally not going to have a bond or a blocked account. But now we're talking about conservators. So the old guardianship of the estate, you got to deal with all the money. So good luck. Here's your fun job. You get to marshal the assets. And that can be pretty easy or pretty difficult depending upon what's going on. One of my general concerns, both in this and estate, is have I missed an account somewhere? And that sometimes is a learning experience. Back in the day when I first started, this was all easy. We just waited for it all to show up in mail and we're good. But unfortunately, mail doesn't work for all of us now. If you check my mailbox, I don't think you're going to get any statements ever. So you've got to start marshaling the assets. So find out where the bank, go to the bank, take your beautiful, pretty blue letters and transfer those funds from an individual account or scarily a joint and survivorship account, maybe with somebody else, into a conservatorship account. Make sure everybody's got copies of your letters. And then the next thing comes up, and this could apply to a guardianship. This is a little bit crossing the line. If you opt Social Security or other benefits, you maybe will want to becoming a payee. So a representative payee is an individual under Social Security and the VA are the two most common ones that can handle money for somebody else. And I hate to bring constitutional law into this at all, but quite honestly, Social Security and the VA are not going to pay any attention to our lowly superior court orders. For the most part, they're going to say we got our own process. So it's very possible that you could be in a situation where you're a guardian for somebody and the lesser restrictive alternative is I'm a rep payee and then they don't need a conservator. Because in theory, under a representative payee situation for Social Security, somebody is looking over the shoulder of the individual. I think the reality is they're not. So this is one of the things you want to start on right away. As Liz had said, this can take a lot of time to get the money wrapped up and sometimes longer than 90 days. Sometimes you do this. So you don't get appointed and then start working at 90 days, start working right away and get the money. I'm going to tell you a bad situation I'm dealing with right now was the money was sitting in another state in an account with somebody else's name on it who decided they were going to help themselves to the money. So they walked off with some of the money of the individual and we're trying to get it back. So this is very important. That situation, as I said, was another state. I think the Constitution, again, is pretty clear that we honor court orders in all states, but the state didn't see it that way. They said that you can't have a Washington guardianship with assets in another state, and it became a big, big, big mess that hopefully we'll be able to fix at some point. One of the other reasons it's really good to get this done sooner rather than later is at your 90-day hearing, you got to file an inventory if you're a conservator. You got to put what the assets are on there, and it's really hard to know if you don't know what they are. So very important to find the assets. Will I say that we're 100% right? Probably not all the time. I've had to amend inventories once or twice where we found something down the road. It used to be, in my mind, it was all the AT&T Bell spin-off stocks, but you might find assets down the road. And we'll talk about that in a second. Okay, what do? You've left the courthouse. You have not taken your order out of the courthouse. And there's a reason we both brought it up is, that might have happened once. I might have done that once and I never did it again. So what do you do next? Well, our guardianship law can be really fun sometimes. When this was first started, they had a bifurcated 14-day, 13-day notice that needed to go out. So 14 days, you basically have to send the order appointing guardian and your notice of rights to the individual. This is actually not 100% correct statement. That's not actually what the law says. I think today the law says the conservator has to do the order, but the guardian has 30 days. But my advice for everybody, practice tip, is get it all done within 14 days, get the orders out, because then you don't forget and you're not confused. Is this a 14 or a 30-day situation? When originally, I think it was guardians had to do it in 14. I think you had to send the order in 14 and then the notice in 30. And then they changed it and it's now a little bit different. And I think they intended to make it 30, but that's not what happened. All right, contact all the governmental agencies which they receive funds from. Contact any debtors, because you're also going to be responsible of debts if somebody has any debts, and review the mail and documents of the individual. And that hopefully will help you find what you need. So we're now 14 days from the hearing. You've sent out all your orders, your notices. The reason we do that is what was respondent when we were in the petition side, they're now turned an individual, has a right to object. They have a right to object to anything. Intellectually, I both struggle and understand this, because what we've done with the guardianship is we've probably removed their right to contract and removed their right to be sued except through the guardian, but we're continuing to send them documents under the guardianship situation, which I think intellectually is very interesting. But I also understand why the legislature wanted it that way, is if you do have somebody who's under guardianship, who should be under guardianship, we want them to get the court stuff so that they can come in and object. It happens, interesting stories happen with this. I have a guardianship client who the individual has a decent amount of capacity in small bursts. And what they like to do is they like to call up Social Security and report my client is deceased. So my client has died something like 17 times over the last 3 or 4 years. He looks pretty good for a dead guy, but that is, that's part of the process. Is you do unfortunately sometimes have individuals who are going to make it difficult to do some of the jobs, and be aware of that and know that going in. Some individuals are not ever really going to be involved. Some of them are very involved. All right, so we're on the initial climb out. We've got what needs to be done. And now we need to start thinking about what happens if something changes. So weather gets bad, we can't land where we're planning to land. What do we do? Well, there are, and generally in the statute, just so you know, there's 2 separate sections. The 300s generally deal with guardianship, so 11-130, 300, and the 500 generally deal with conservatorship. So that's why you'll see a lot of statutes. They don't mirror each other exactly, but they often mirror each other requirements. So if you do have a situation where a person moves, a person has major financial change. So let's say an example of that is they were involved in a lawsuit, and that lawsuit has come forward, and now they're getting $500,000 in this lawsuit. You need to report that to the court. If they have a life-threatening injury, you need to threaten that to the court. Threaten that to the court, report that to the court. If they pass away, you need to report that to the court. And if they have been in the hospital for more than 24 hours, you need to report that to the court. So you have some duties of saying, hey, court, I need, this has happened, here's what's going on, so the court knows where the individual is. At the very beginning of this, Ms. Johnson mentioned court visitor. Well, I got appointed as court visitor in a case where right now I have no clue where the individual is, and that's really scary. I hope I can find them as part of the investigation, but when they were petitioned, they were in a hospital, they were discharged from the hospital. Supposedly the facility they're discharged to has never heard of them, and they're out in the wind somewhere. So that is very important to keep everybody up to date on what's happened. Okay. I feel like I need to explain some of this. Contract air traffic control for instrument flight rules clearance. I'm going to tell you right now, I'm a VFR only pilot, so I don't deal with the instrument flight rules. That's what the professionals are for. But we do need to have a hearing at 90 days. Now, the hearing is not at 90 days. Your documents are due at 90 days. And I'm going to roll back a little bit just because we have a lot of people who may not do this, and explain a little bit practice, at least in Pierce County. One of the things that confuses everybody is when you file a guardianship petition, there is a mandatory review with the judge. The judge does not hear anything on these matters generally. There's probably always exceptions until a guardianship has been appointed. So up until a guardianship is appointed, the judge isn't going to hear anything. There is a mandatory review. One of the things that does exist that we did not mention is when you open a guardianship petition, it is supposed to be completed within 60 days unless it is extended. So hopefully what happens is you petition, you have your hearing on day 59 or before, and you do that before the commissioner. So one of the things that pro ses and new attorneys kind of struggle with is how you do this. So a hearing gets set before the commissioner, the commissioner makes the determination, and we've been talking about what happens next. Again, generally, you're going to have your hearing on your documents, your 90-day documents, which are the inventory and the plan, before the commissioner. How this all works? Well, the statute says they're due 90 days from date of appointment. This is a weird one. They have to be in the court file, and notice has to be given for 30 days. So if you file your guardianship inventory and your plan today, no matter what you're doing, you legally cannot hear them for 30 days. And that's to give notice. It's weird, and it's the only one in here that has that time limit. When we get to reports, your reports have to be filed by a certain time, but there's no statutory requirement of when the hearing needs to be held. So I guess if you file your report in 90 days, you could, your plan within 90 days, I guess you could procrastinate for a while, but that's not a good idea. So try to do it around 30 days. The guardian conservator has to get the forms, file the forms, get working copies to the commissioner, send copies to all the notice parties. And I'm going to step back on my soapbox because I think we have some time here. Notice parties is an interesting question. One of the things I do not love is when we have 90,000 notice parties that we need to give notice to. So one of the things I like to do is kind of limit who the notice parties are in these actions. There is a statutory requirement of who has to be served the petition. And I don't really feel it's the same group has to be given notice. There is a process to ask to be given notice. It's also something people mess up all the time. It's not unusual to see in a guardianship a request for special notice, like if you're doing a probate. That is not the process. There is a process under 11-130. You file, the court approves it, and then now you're a notice party. Also, in the order appointing, there can be notice parties listed. As I said, I kind of keep them to people who are really involved. So like one of the ones under the statute is we have to give all the siblings notice of the petition. But if you have siblings who just aren't even involved in this person's life, I don't see the reason that they need to give notice unless they want to come forward. I think if you have other attorneys, you might get a different view of who should be included as a notice party and who shouldn't be included. But I like to keep it to a minimum because you can spend a lot of your client's money on these sending out notices to everybody if you include everybody. At that point, once you file everything, you wait your 30 days. Then at that point, you have the ability to go before the commissioner again. You have a very quick presentment of I've filed my documents, no objections have been received, and you move on. Now let's talk a little bit about the documents themselves. Quite honestly, the inventory is very clear, lists the assets. Like it's real easy. The plan is the more interesting one because it asks a lot about future vision of what's going to happen here. I think what the goal is, and Ms. Johnson said earlier, people want to write a book. I like to keep the plan kind of vague, and I like to keep the plan kind of general because we don't want to have to go in and file a new plan because we're making changes. So if we have a child with autism, I might lay in there, at this point, they're going to community transition program. They will eventually move on to doing something after that, but I'm not going to get into minutia of what's happening. I'm also not going to get into minutia of how, they're taking classes and they're all this. I'm going to put in education. So try to be helpful, but still vague. So don't get into too many details. Like on Tuesday, they go here. On Wednesday, they go here. I don't think that really helps in the plan, but I have seen people who want to include a lot of stuff. I think sometimes our clients do like want to tell a story or don't want to tell a story. It goes both ways. And it's just a matter of getting the information that is relevant, but not too much information. Now, you may be saying, hey, Jim, you've been talking about all these documents. Where can I see them? Well, they're all on the Washington Courts form. The link is included there. You can also, I just type in Washington Courts Guardianship and they come up. They change them occasionally. I do edit my documents a decent amount. My orders appointing have different things in them that I think are necessary. Often what I do, I like to keep it clean. Like I hate checkbox documents. I also have some real leery concerns about checkbox documents. I once had a situation in King County where the bank wouldn't accept my order because they said there's checkboxes here and we don't know who checked these boxes. And well, that's a court order and I don't think anybody's modifying it. I do see where they're coming from of what is the best situation moving forward. So I just took out all the checkboxes. I put everything in some sort of legal English. I also, if I have only a conservatorship or only a guardianship, I take all references to the other things out there so that it's pretty clear what the judge is looking at. I like to kind of keep them readable. I like words better than numbers, and I kind of hate, as I said, I hate the check boxes. I think they're kind of silly. So that is what we have. We have lots of time, and I have no idea if we have questions. So I am going to try to turn off my screen sharing here. As you can see from all of this, I am really great at technology. And it's interesting because I've got two screens and I've got something on one screen that's then magically not on the other screen. So give me a second here. There we go. Maybe that's what I'm looking for. All right. So.
And one other thing that we did forget to mention, since we do have extra time, is if you do want to be paid for your time as a guardian or conservator, then we want to make sure that you're logging all of your time and activities. So there's no necessarily like exact perfect way to do it. But what you want to look at is keeping track of the date, the time, the stuff you're doing. I've had people use like a wall calendar and just really write things down. But you do want to demonstrate to the judge or commissioner, whether you're asking for reimbursement or not, that you are doing your fiduciary duty. Remember, this isn't a volunteer position. So on more than one occasion, I represent a variety of different guardians and conservators, some professional, some not. Where the person subject to guardianship says, I've never seen them before in my life. They don't visit me. They don't feed me. They don't bring me clothes. I was in the hospital. I never saw them. So having that detailed log of, shopping for a person, balanced checkbook, called hospital to get updates. Sometimes people are confused about what a guardian has to do. Guardian conservators are not caregivers. They don't come and maybe change your wraps if you have bandages. They don't help you get dressed. They don't do those things. But it's important that the guardian or conservator is demonstrating that they are involved. And the best way to do that is with a contemporaneous log, just like you would if you were an attorney. Jot down how much time you're spending, include your travel time, all of those things. And two questions popped up. I'll address the one that's related to this. Are there software programs that you can recommend? Absolutely. Depending on your budget and how many guardians or conservators you're working with, there is a special guardianship software called EMS that does all of this stuff and helps you prepare reports and track all the data. But you can use things like QuickBooks, or most apps on your phone will track. There's mileage apps, there's QuickBooks where you can do invoicing, and then you can also link it to their bank account and balance their account every single month. You'll have the reports ready to go at your 90-day or your annual report. It will help you reconcile it. There's also Quicken. I don't endorse anyone. No favorite companies. I'm sure that there's also free ones. I've seen people use Excel. I've seen people use a little black book. And if you had one of those, it's one of those old record ledgers. It's how my parents used to keep track and how I had to balance their accounts. So anything will do. You just want to remember that just assume that everyone's going to assume that you're lying. and that you have to have some evidence to back everything up. So even if you're giving your person, say, cash as part of their allowance, because they are subject to guardians for conservatorship doesn't mean that they don't get to spend any money, and you can't necessarily require them to give you a receipt. You want to have some method for tracking that you gave them something, ideally a witness, but maybe not. Just something showing that you gave stuff over to them. If you go shopping, having a good log of the receipts and what was purchased. A picture might be a little bit far. I don't think that a lot of people do that, but it doesn't hurt to have a photograph of what you brought for the person, because when you spend $300 at Fred Meyer, how do I know that you got 6 t-shirts for that person and not 6 t-shirts for you? So I think anything you can do to better protect yourself is is in your best interest for your client and for your person. I know, thank you, Zach. That's a very dark view, though, to assume that everyone assumes you're lying, but it'll be better if you just do it that way, and then you can have all of the backup that you need. So Beverly had a question that, can either of you speak to modifying a guardianship plan after the co-guardians divorce and are not on the same page anymore? I refer those cases to Jim Bates. That's what I'm just kidding.
I guess the question I would ask, we're talking about adult guardianships.
Yes.
So I have seen situations where the family is still fighting. I think the honest answer is that's something where maybe a CPG, certified professional guardian, might need to step in. I do see situations sometimes where we do have co-guardians who are the parents, and they're working well and then not working well. And most of my cases, it's probably after divorce. I've actually never had one that divorce happened during the guardianship. I've had people come to me. And I think the issue you have is who is able to do this. And if I was sitting down with the client and they're saying, we're getting divorced, would you modify the plan? Well, you might have to, because the person now might be residing between two residences. I think that's a really important thing to modify. The more interesting question is, can they still be co-guardians? And if they're willing to work together and kind of put down all the family law stuff, which is often hard to ask of people, and work best toward their child, they still can continue to be co-guardians. But I think if we're going to be cynics, and Liz started us off down on that road, we're going to have probably a meeting at some point of who's going to do this. Are we going to work together? And I see this spot all the time when I'm sitting in a commissioner's calendar on the minor docket. I think it's a matter of time. Now, the case I was involved in was in Kitsap County, and let's just say nobody was the appropriate guardian at this point. The good news there was this is a situation where between the individual was one of these young people with autism that was right on the edge of a guardianship. And I think the parents jumped the guardianship a little too soon. And then now this person's 22, 23, I forget how old he was. And he's able to make most decisions. He needed a little bit of help. So we did an other protective arrangement in this situation where he got a little help. It was neither of the parents. And then at that point, we had the guardianship dismissed. So that was really good. Now, the bad part about this story is it was pretty contentious. And they spent a lot of time presenting to the commissioner, can't remember if it was commissioner or judge, but the judicial officer, about how all the other one had done all the things that were bad. And at that point, luckily, we had this whole plan. The individual was released from guardianship. And then I hate to say where this went next, but we're in a courtroom, and the new girlfriend of the husband decided to pick a fight with the old wife of the husband, and security had to come. So don't do that. I think we all know that already. Don't get in a fight in the courthouse. And if you're going to do it in the law library, just to provide Amy some entertainment. So let's talk.
I want to roll back to that conversation, because this is a conversation I have a lot with parents. Adult guardianship is not a continuation of a family law custody arrangement. And I think that that is where I have more difficulty explaining to parents who have been the child's guardian, right? Because you are the child's guardian when they're a minor, whether it's formal or informal, and you're in charge of a lot of different things. And then you're stepping into this fiduciary role. You are not a volunteer. I understand that is your child, but you have a duty to perform in the way that essentially a stranger might. Now, it's better that you have this insider knowledge, but it doesn't allow you the right to continue the conflict. Not that family law encourages continuing the conflict, but you don't get to then continue to be the parent of this child. Your fiduciary duty outranks that. So even if you don't like your other partner, if the parenting situation is generally split and you can't make an adult live anywhere, right? So under the guardianship statute, you can't force an adult to maybe go to the other parent's house. However, you also can't say, gosh, I wish you weren't going to mommy's this weekend because I'm going to have ice cream tonight and now you're going to miss out. So you have to be careful about what you're doing. And if you are going to interfere, then more likely than not, one of you is going to have to stop being the guardian conservator, or as Jim said, you're going to have to look at a certified professional guardian if that's even an option, because sometimes there isn't money. The statute has an order of priority about who is supposed to be the guardian conservator in these situations. And there's always that caveat, right? Like, unless, so if you're going to create conflict for your co-guardian, or you're going to do inappropriate things, and inappropriate things I've seen are moving without telling the other parent, even out of state, making changes to their plan, being unwilling to communicate when services change, like support, DDA, income programs and activities, failing to follow through on the things that are in the plan that they're supposed to have for their enrichment. So say when the parents were together, they were taking them to job training skills or to counseling, and the other parent was never really on board. So now that they have custody, which basically means the adult lives with them, you don't really get custody, and they have the decision-making power or half the decision-making power, they are now going to cut out those programs. I also just want to remind people that if you are co-guardian, you have the same duty as the other guardian. So if that guardian takes the person out of state or changes their activities and services or refuses to communicate with you, you equally have a duty to inform the court that that has occurred, and you should probably be heading back into court to at least adjust the plan, even if you're going to agree with it. Taking the person out of state, cutting their programs, their social services or educational things, or not getting them to their medical providers, those are all things that you still have a duty to do. I've never seen a guardianship order where it's like, guardian one is responsible for medical and guardian two is responsible for education and guardian one is responsible for social and guardian two is responsible for something else. It is, you are appointing co-guardians. So it's different than being a co-parent, because the court is sort of who you are appointed by and working for. And you kind of have a duty to go tattle if things are not going well.
Okay, I see there was a question that I'll handle. Would you recommend having one parent who has historically been the primary caregiver of a developmentally disabled child who is now of age be appointed guardian as opposed to both parents? So I'm going to dig a little bit into this to kill some time. The first question is, I'm going to throw my bias out here. I've got two biases on this topic. My bias is I don't like co-guardians. It can often cause a mess. It can cause a lot of situation. And as Ms. Johnson said, a lot of people want to fight out. They want to use the guardianship as an extension of, and I'm not a family law attorney, so I'll get this wrong, the parenting plan. This is a completely different thing. So I think logically it makes sense if you have a primary caregiver, they may need to be the guardian. Conservator is a little bit more different. Conservator is the money person, so we want somebody handling money. Now, what I want to back up and talk a little bit about, and this is where my other bias comes in, is I flat out have a bias. We do not get a guardianship for a developmentally disabled person just because they turn 18. I know that has long been how things operate, but that is not what the statute says. Remember, we have a three-pronged test to have a guardian or conservator. So we can agree they're probably disabled, but what harm is coming to them, and can they execute a lesser restrictive alternative? So what I think needs to be done is you need to look at this. Okay, they are disabled. Do they need a guardian or conservator? And of course, it's the lawyer answer. It depends. How disabled are they? So one of the most interesting things I've noticed is the more disabled an individual, the less likely you probably need a guardian and conservator. So if you have somebody who really never leaves their house, they're always with a parent, they always have a parent at their medical appointments, they always have a parent everywhere they go, they may never need a guardian or conservator. Now, you might be saying, well, how did they deal with medical stuff? Well, the medical stuff, there is a statute that maybe our medical industry doesn't know exists called informed consent. It's RCW 770065 that says a priority of people who can make decisions when an individual cannot. My position is that controls. You don't need a guardianship if you're a parent with a disabled individual who's obviously disabled. Oddly, our friends in the medical industry don't always agree with us. So we end up struggling having to do guardianships for minors that don't really need them. Now, why would you want a guardianship when you got to go see the court at best every 3 years, spend money every 3 years when you're able to make decisions under the statute? I would love someday, well, I don't because I'm not a litigator, but I would love someday to sue a facility who won't honor our statute and see what the courts would have to say, because it's pretty much black and white. They can make decisions. The other problem with minors, with the disabled individuals who were minors are now adults, is just because they're disabled doesn't mean they don't have some legal capacity to make decisions and potentially execute a power of attorney. This is where my bias really gets me frustrated. Is I get told all the time by doctors and teachers and this, well, they have autism, they're disabled. And I want to argue, well, that's not what the law says. The law says you have capacity until you're found not to have capacity. And I see a lot of pretty high functioning children with autism who are in guardianship that I question in the past before we changed the law. And I question if it's what's best for them. So what I tell everybody is think very, very seriously of, don't just automatically, they've turned 18, go get a guardianship, or don't listen to the school that says that they're 18, they have to get a guardianship. I still want to see the law that says that, but I've been told that many times. And I'm stealing this from Ms. Johnson, I'm giving her credit, guardianships are reactive, not proactive. So what would happen is let's try to operate and see how the 18-year-old is dealing with things. And you go to the hospital and they say, we're not treating you anymore. That may be a time to do a guardianship. The individual that's being listed at 28 cannot make decisions for himself, filled in diapers, legally blind, cannot feed himself. It kind of depends what you need the guardianship for. If he's being treated under the informed consent statute and his parents or his rep pay for Social Security, there may be no need for a guardianship or conservatorship. But if he can't get treatment or the doctors say he needs to make the decisions, then at that point you need guardianship. The other thing that kind of is my bias, and I'll be open about, is I don't think just because you've got an individual who's disabled, we need a conservatorship. Because if they don't have any money, what do they need a conservatorship for? And the answer I often get is, well, they might work someday. I'm like, well, then do the conservatorship then. Again, it's reactive, not proactive. So every one of these cases, it's sit down, look at the individual. What do they need? Do they meet the requirements? Number one's going to be easy, but what are they not able to manage? And what are the other lesser restrictive alternatives? And I've gone so far as to use picture communication with disabled individuals, to do other ways that's not, we can't have a conversation, but maybe they understand enough to say, I want mommy to help me. I do think, going back to the question before, if we do have kind of a family law background, my preference would be to have one person as guardian and the other person as a notice party. And that's a time when the other parent absolutely should be a notice party. After saying we have too many notice parties, when you do have two parents, no question. What I try to have is have a serious meeting with them of, can you work together? And amazingly, when they're in my office, they can all work together, and then we're in court 6-8 months down the road because they can't work together. So I hope that answers that question. I
have another question for you that popped up, and I'm hoping you'll screen share the forms when you answer it. But I've been appointed several times as a court visitor, either because somebody is transferring a guardianship here and they're filing a new guardianship. So they have one in Colorado, Florida, wherever. They get here and they file a brand new guardianship, or they need to leave the state. And so they don't do anything with this guardianship. I've been reappointed because it's 4 years they're missing. And we find out they're in California, Belize, wherever they are. So there's a process to address that. So could you talk about that process and then maybe also share the form?
I will talk about the first one. I've never done the second one. I've never had, well, I've got one now. Somebody left. Yeah, so you don't get to just go open guardianships wherever you want. Technically, there's no reason a Washington guardianship would not be valid in another state. I actually have one, and it's Colorado, which is freaking me out that Ms. Johnson mentioned that, where the Colorado court seems fine. It's a conservatorship. I don't see why it needs to be done, but there absolutely is a process to transfer. It is absolutely not open a new guardianship. It is. If you look at the guardianship forms, and I am not going to try to screen share again because I am going to mess that up, but it's GDNT 701 through 712. And generally what the process is you file the petition to transfer guardianship from another state petition to transfer guardianship and conservatorship. Now I'm talking, that's the one to go out. 701 is to go to a receiving state. 703 is the one to bring it in. No, that's terminating. So it's, 705 is the petition to accept a guardianship from another state. Generally, what the process is going to be is the other state has an order said, we'll potentially transfer this if the Washington court will accept it. It's a little bit goofy how other states sometimes are. I'm not going to talk too much about the past, but when I used to practice law in the state of Ohio. This was the 90s, and in the 90s, they did not have a law that contemplated a transfer of guardianship, period, end of story. So I was working with the commissioners, which we called magistrates there, working through this, and we're kind of all just blind because the statute never had that. It does now. So Washington has this. You can transfer guardianship out of state, you can bring one in state, and you can move counties. And as I said, that's all the GDNT 700 series. What basically, as I said, happens is you get an order from the other state provisionally transferring it in. You come here and so they provisionally transferred it. You do not need a court visitor appointed. I think the court has a little confused on that one. And at that point, you then get all the documents moved over, you get all the documents necessary, and then you do the final order. So that provisional order is 706. And final order is 707. So you're probably going to file the first one with the court, and then you're going to set a hearing once you have all the stuff. And then they would issue the final order accepting transfer to Washington, which is GDNT 708. The reverse process exists, 701, 702, 703, and 704. So same kind of process. I do not know, because I'm only licensed to practice here now, what other states say, but most of the West Coast states have had to deal with California. And when I've done a transfer, it's the same process. This is supposed to be the Uniform Guardianship Act, so hopefully it works. But yes, do not start a new case. The other thing we haven't talked about today is there are a little bit goofy processes called emergency guardianship and immediate emergency guardianship. These are really confusing for a lot of people, including attorneys. They are two different processes and they have two different outcomes. There is also an immediate conservatorship, but there is no immediate emergency, sorry, there's an emergency conservatorship, not an immediate emergency conservatorship. I see orders that seem to say that, but it doesn't even exist in 11-130. So if there is a true emergency, and I joke all the time that an emergency is you're walking naked down I-5 giving everybody your money. Like, I see a lot of people file emergencies that I'm kind of scratching my head why these aren't just standard guardianships. I think a lot of people think their situation is always an emergency. Somebody not paying their bills, to me, really isn't an emergency. That's typical guardianship. Maybe if you need to place somebody and they're in a place that they've got to leave, that might be an immediate emergency. I had one where the gentleman had a stroke and had nothing in place, and that one was kind of an interesting one. I still kind of questioned if that was an emergency, so maybe that's my third bias. But basically, under 11-130, you've got the typical guardianship conservatorship, you've got the emergency guardianship and conservatorship, and for the really crazy cases, you've got the immediate emergency guardianship, all under 11-130. Now, Ms. Johnson wanted to know how we transfer in and we transfer out. We talked about that. Let me see what other questions are coming here.
I have a question from the audience. What about if you are an attorney and you don't, or if you're not an attorney and you have a situation you're not really sure what to do? So I will see a lot of families who maybe they want to borrow money from the individual, and the individual is maybe just under a conservatorship, so they still can make personal decisions. If I really want to lend my brother money, can I do that? Or what do I do if my sister really wants to borrow money? And that was a habit maybe prior to the guardianship conservatorship. What would you do if how would someone identify those conflicts? And then what process is available to do it? Should you just wing it and see what happens? And I want you to answer it because I want everyone to say Jim Bates said I should. I don't want them to say Liz Johnson said I should.
So what am I supposed to answer? And do we have to give Isla credit now that she's on the call?
Yes, Isla desperately wants to know about this information. My daughter Popeye and does not care that we're in a CLE. Identifying maybe some of those conflict interest areas when you're the guardian conservator. So when you are the guardian for maybe your child who is an adult and they want to spend money in a way that you don't like, or maybe you want to borrow money from them, and that's something that existed before the guardianship. It was fine. They said, hey, yeah, you can borrow my money. It's not a big deal. I'm happy to lend it to you. What are some thoughts around that circumstance that comes up?
Okay, so this is a really easy one for me. You don't ever take money when you're in a fiduciary relationship. So one of the situations, and I'm going to say this applies to guardianship law. I've always dealt with this under power of attorney law, but once you're in a situation that you are a fiduciary, the burden shifts and you need to show what you did was appropriate. I do think if there is a long history, you might be able to show that for the court. One of the things that exists, and it's on the guardianship forms, and I don't know the number off the top of my head, and I've been tongue-tied with numbers today, so I want to be very careful, but there's a petition for instructions under the guardianship forms, and Ms. Johnson may throw that in the chat if she has that on the top of her head. I think if you had a situation where you are looking to borrow money from the individual and the individual is on board, one, my advice is don't do it. Just don't do it. Find another source of funds. If you're going to do it, you could try to do a motion and declaration for instructions, which I am learning here is guardianship all 034 and 035, and maybe the court's going to grant it. The problem I have with that is you're breaching your fiduciary duty and you're getting yourself in a lot of trouble. Now, I think the more holistic question that comes up here, and we can chat with this a little bit. And before I do that, I wanted to answer, I think it's Kiera, would a power of attorney work in that situation? If an individual has the ability to do a power of attorney, it's always the better choice. Period, end of story. There might need to be some other things, but I am the huge fan. Everybody get power of attorneys. They're very important. Get that done. Now, going back, as I try to go all over the place, one of the things you need to really look at when you are the guardian or the conservator is what your powers and duties are. And this becomes a problem for a lot of people. I have people who want to do a guardianship. because my son is living on the street and he is doing drugs. And I try to explain to them, I don't think the judge is going to come over and sit at their house and watch them so they don't do drugs. Technically, you cannot force a person to live somewhere specifically under guardianship law. I put a little asterisk next to that because certain courts, you could issue a motion and instructions and they might agree to it, but statutorily, you cannot force where someone lives. So if someone's living on the street, you cannot be appointed guardian and force them to go to rehab, force them to do this. You can't do these things. You also, arguably, cannot force them. One of the things I see with a lot of my clients where we have the 18, 19-year-olds with autism is everybody's fighting about screen time and what you're able to do. I think that the guardianship's not always the ideal place to deal with that either, because you have a situation where, can you limit who they talk to? The statute says no. Again, with an asterisk, there is a process that if somebody is a very, 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 very bad actor, the court can say they can't have contact with them. Done this once or twice. I had a situation where a young lady got married very young. The spouse basically did nothing other than he wanted to be the spouse when it benefited him. He did not look after this individual. This individual had some mental health issues. And we did put in the guardianship order that the spouse could not have contact. That's the only time I've done that. In that case, the individual absolutely did not want to be did not want to contact with your spouse. I've also had it seen on the other side, and this gets into family law. And again, I'm not a family lawyer. I had somebody file a petition to force visitation for an individual. And if you can't force somebody to stay away from so-and-so, I don't see that you can force somebody to see so-and-so. And in this situation, it was one of these petitions I kind of dislike. It's, here are my feelings, not any law. And my argument was there's no way to force an individual to see anybody. There's also a whole lot of background of bad actors and all that kind of stuff. So you cannot control social decision-making. You cannot control, I saw one, I think I was on the docket one day, and it was, we want to keep this person away from no good, so-and-so partner who's also in their teens and 20s. That's not what this is for. Those are what protection orders are for. Those might be what vulnerable adult protection orders are for, but that's not what a guardianship is for. A guardianship, again, is helping them make medical decisions, taking care of their medical and managing their money. It is not keeping them from out of trouble. The other thing is we also don't get to tell people how they live their lives. What you and I might think, well, if you saw my life, you might think he's pretty eccentric. If somebody's eccentric, that's not enough reason for a guardianship. If somebody lives in a hoarder house, that's not necessarily a reason for a guardianship. People can choose to make bad decisions. Somebody not spending their money the way we want is not necessarily a reason for the guardianship. And if all those reasons were guardianships, we've had a lot more guardianships. This is where every time I do one of these, I joke all the time that I'd like to be under guardianship, simply just to remove my right to marry. I've been divorced twice. Clearly, I don't have that power. But again, that's not what a guardianship is for. We can't keep people from making bad decisions. We're there to protect their health, safety, and welfare. Going back to something Ms. Johnson said before, I get really nervous when conservators end up in a situation where they are giving people cash. It makes me nervous because what I'm worried about is, how do you prove what that cash went for? And the judge could absolutely ask about it. In fact, I was in court 2 Fridays ago, and the judge was asking, so I see $60 at Amazon, what was that for? And in this case, the guardian had some notes. It was for some tracksuits or something like that. And that was good. But if you're giving them money and they're spending it, sometimes it's hard to account what they're doing it for. And depending upon the judge you're before, they may say, oh yeah, you give them $100 cash each month, we're good with that. Or they may say, what was that $100 used for? With our online world, it can get a little embarrassing. I had one of these where the individual, I think, was paying for pornography on his computer, and I didn't really want to put that in the report. So we just put he was getting cash, but it was some very interesting charges on his debit card. My preference is to give somebody a debit card, and that way you can track what everything is being used. So I don't love the idea of giving cash. Now, how do you end a guardianship? And can a person under guardianship request to have it changed or to change guardians? The answer to all those is yes. Due process requires that every year when we do all of the mailings that we do for reports for this stuff, a copy has to go to the individual, which is the person under guardianship or conservatorship. At that point, they have a right to come into court and say, I don't want this anymore. And this is where it gets difficult, sketchy, and where sometimes our job can be hard. So if you have an individual who you think doesn't need the guardianship anymore, so let's talk about the person who got the guardianship at 18 with autism, they're now 25, they're working, they're doing pretty well. They maybe need a little bit of healthcare help, but that's it. Well, the first thing I would do if I represented the parent is the parent does have a duty under the statute to say, I don't think my child needs a guardianship anymore. And I think that's a really interesting thing because I've had that thrown at me by other counsel. The counsel's position was, I represent the individual. This individual doesn't need a guardianship, and your client breached the guardianship by not saying they didn't need a guardianship. But that becomes an issue because in my case, my individual or my client thinks they absolutely do need a guardianship. So often what you're pitting is the guardian against the individual, which can be hard. One of the issues here is people's disabilities do show that they're not able to handle things sometimes. And I think at that point, you've got to look at what is the danger and what are the options here. And there are a couple options. Option number one is if the individual, let's just say the individual writes a letter, sends it to the court and says, I don't want the guardianship anymore. If I'm the judicial officer, the first thing I'm going to do is set that for a mandatory review. I probably think at that point, the individual needs counsel to assist them with this process. And at that point, they need to have an argument of why they do not need a guardian. As Ms. Johnson put in there is an 11-130-355 that does talk about terminating the guardianship. The two easiest ways to do it is a prima facie, some sort of medical information that shows they don't need the guardianship anymore. That can be interesting. I've seen that done a few times. I've never done it myself. The more realistic one is you get the attorney in there. The attorney says they have the ability to do a lesser restrictive alternative, a power of attorney, or maybe another protective measure, somebody who can advise them and help them make some decisions if they can't. And at that point, the guardianship gets terminated. I've terminated a decent amount of guardianships with the lesser restrictive alternative side of things. I think there's probably more out there we can do. So there absolutely is a process to do that. One of the questions is, are there resources to help start this process without going to an attorney? Well, my bias is going to come in. I am an attorney. Yes, there is a Tacoma pro bono clinic, and there's this place called the Pierce County Law Library. They have a lot of checklists and books and things like that that you can look at to see the process through. Do I think it's a good idea? Not really. It can be difficult to understand the process for a lot of lay people. One of the things I'm starting to struggle with is how many times I'm getting appointed where a lay guardian is appointed and they just stopped and did nothing. And I get appointed as court visitor, and now I've got to dig out what the next situation is. A person under guardianship, often what we have is people who aren't able to, manifest any level of ability to even understand this, and that can be difficult. Now, costs, to start one, and I'm kind of looking through, I don't know if there's any questions we've missed. The big thing for me is power of attorney, always the way to go. Informed consent is something, if I had a child with disabilities, which I do, I would print out and have in my wallet. Just looking here. We've talked a little about parents. Okay, most recent question. Cost is hard. The court fee is $240. I always say $240, $150 because I pay by credit card. Somebody's singing in the background here. Whoever that is, if they could mute, that'd be great. Cost of starting a guardianship with an attorney is of course varied, but I'd say you're looking at $3,000 to $5,000. It depends on how much work you're doing into that. If you're starting the plan, that might even be more, but it is not insignificant. And that is why I am a big fan, especially for people with disabilities, of look at what do you really need this? And I will tell you, for most people, it's not other than two cases. The doctors won't talk to them anymore. And this one's new for me. The insurance companies won't talk to them anymore. And that one kind of blows my mind. So I've got the 21-year-old who's on my insurance, but because they're 21, even though they're on my insurance, they won't talk to me at all about their insurance. So that might be a reason to need a guardianship. The other thing that we didn't really talk about, who pays for that cost? Yeah, that's a really, really, really good question. One of the things that drives me crazy is the person under guardianship pays for these costs. So I'm going to use a real life example that was really frustrating to me. As those of you who do law, people are interesting sometimes, and they like to fight about things that aren't really germane. So how many estates are we fighting about things that happened in, 11th grade? I've seen guardianships be the same way. So I had a guardianship where a gentleman, a petition was filed by his daughter. Daughter had been power of attorney. Daughter had been allegedly helping herself to the money. Son had filed a guardianship. Son had been appointed guardian. Actually, no, that's not what happened. They'd done new powers of attorney once they'd find this. They found out, the bank had alerted, and now son is power of attorney. Well, daughter's really upset about this. So she files a guardianship saying son is stealing money. And this went through the whole process. And you had three attorneys. You had the attorney for, well, the daughter have an attorney. I think the petition was pro se, but then you had two professionals, the court visitor and the attorney. This gentleman had a lot of money, so it was not a public pay case. And basically, he ended up having to pay for two attorneys when the case was brought inappropriately. Now, there is a statute that if you bring the case without doing your due diligence, you can get paid from the petitioner. I don't see the courts loving that. I know a couple attorneys have had it. In the case I did, they wouldn't even listen to having the fees be reallocated. I argued strenuously that this was ridiculous, that I had to represent the one child, that we had an attorney and we had a court visitor, and everybody's just ramping up the fees and they're coming out the individual. That's the one thing I would change the law about. I would make the petitioner responsible. What the statute actually says is bad faith. I think my case was about as close to bad faith as I've seen. But what really is bad faith in this situation? I wish it would be maybe a little lower standard, that you didn't do your due diligence or something like that. So that's where it's frustrating. Now, for a lot of the guardianships that happen, when you've got the disabled individual, those are going to have a court visitor and a respondent attorney who will be public pay. This also brings up something that I find flummoxing in the statute. So when 11-130 first came through, you had to file an adult guardianship, the individual had to be 18. And they changed that. They allow you to file for an individual before they turn 18, which I have some due process concerns with. So what you're telling me, you can file, you can go through all this process. I guess they can have an attorney appointed when they're underage, and then you have a hearing when they turn 18. Seems a little bit weird. So what I wonder in that situation is, if you file on the day they turn 18, that individual has no money. That's a public pay case. That's fine. But when the parents with a lot of money are filing ahead of time, how is that not private pay and on the parent? to be paying all these parties, because that's still an individual who is under 18. So I think what the proper process is file the day the individual becomes 18. I don't think that's always necessarily the right choice, but that's when it should happen. I kind of hate filing ahead of time, because I think you've got a person who's a minor who's somehow under some weird adult guardianship process that you maybe can make an argument that they don't get their stuff. That's the other problem, going back to what we had before, is when you are the guardian, you're a fiduciary, you are managing this money, and while they are your child, you're not really acting as a parent right now. And for a lot of people, that can be difficult. So that's the other thing to think about, is maybe it is good to have somebody else be the guardian for the individual, though a lot of people do that. It depends what you're looking to do. Are you looking to deal with medical stuff, or are you looking to kind of continue the parent-child relationship as they're an adult? And if that's what you're trying to do, guardianship's not the process for that. It's a pretty limited process for pretty limited reasons. And the problem that a lot of people do. Now, do you have any resources to assist with questions besides RCW? I don't know a whole lot of stuff that makes this easy. I know Liz at one point did a little book that's in the law library that I think lays things out. I think one thing she and I probably should think about is maybe taking this process and doing an actual checklist of all the things you need to do for this process from beginning to end. I think that would be helpful for attorneys and for people. The big one there is Tacoma Pro Bono, I think, has come in. And it breaks my heart every time I do Tacoma Pro Bono, because I have these people coming in with questions and with these stories, and they're awful stories. Like, I'm living on the street, my son's living on the street, I want to be his guardian, I want to get him off drugs. And they're all doing the right thing, but that's not what a guardianship is really for. That is something that maybe you can do a little bit of, but you can't send them in for treatment. You can't force placement. In fact, this is a bizarre situation I had, and I was the respondent's attorney in this one, where an immediate emergency guardianship was brought because a facility was refusing to admit somebody for some mental health stuff that they agreed to, that their power of attorney agreed to, simply because there was some language in their power of attorney that said there will be no mental health treatment under this power of attorney. So you had the respondent agreeing, you had the individual agreeing, and that's where, and I don't have the statute off the top of my head, but there flat out says, until you're deemed incapacitated by the court, you have all the rights of an individual. I don't care what your diagnosis is. I don't know what you have. There's not some magic doctor says you can't do this stuff. Now, that wouldn't be the same advice if we're talking about executing a will. Maybe that's a little bit different, but an individual has rights until a court says they don't have rights. It is a legal question and a legal determination, and a doctor can weigh in, but you don't want the doctor telling you, I don't want the doctor telling me how to do a guardianship any more than you want me telling, how to do surgery. Like, talk about, we have our lanes, we are trained for our lanes, and why don't we focus on what we do instead of getting into other lanes? And I know people are looking out for individuals, but I think we have a lot of disabled people who are under guardianship who don't need to be. And I'm glad to see, as time's going on, more and more people getting out of guardianship. The other one, and I should probably throw Ms. Johnson under the bus, she had one that was absolutely insane, and it dealt with getting a passport. And I find it interesting that we have a nonverbal person applying for a passport, and that's the time the federal government wants to recognize our orders, when they have, for Social Security and everything else, that we don't care what state orders say. So there's a lot of weird things that can happen. Luckily, she got that one. The person got their passport. They got to know where they're going. And what I would say in general is, I think as a society, we need to do better about giving agency to people with disabilities. And I think we're getting there, but I wish the education world and the medical world would understand that people do have agency. Now, one of the things that I do understand is it's really hard when you're dealing with the person on, on the floor who's doing the treatment in the emergency room, this is not the person to have that argument with. But because they're just trying to, the nurse is trying to deal with things. But I wish hospital staff would be better educated, and I wish their legal departments would do a better job of educating them on what is and what isn't the law, rather than just saying, well, where's your letter of guardianship or where's your conservatorship? One of the other things I think that has been somewhat frustrating to me, who operates in this world, is I have heard, and I don't know much about this, but I've heard about the singer Britney Spears who was under conservatorship. And I don't know what was going on out there, but it sure felt like a different conservatorship than we have. And maybe in that state it is different. But that's what people hear, and they hear all those stories and then they think it's a different thing. From my end, it's generally going to be for healthcare for the guardian side. Placement is the big issue. As I said, you can't force somebody to live somewhere. And then on the other side, you've got the financial side. And I think conservator is a lot easier to talk about because I'm dealing with the money. But keep in mind you're a fiduciary. Keep in mind that matters. Keep in mind this isn't just an extension of a minor guardianship or parental rights as a minor. It's just one of these frustrating situations that you've got to use the appropriate, I talk about, as maybe this is a little bit silly, but as I don't really call myself an elder law attorney, but as a wills, trust, estates, guardianship attorney, we have different arrows in our quiver for different things. And guardianship is one of those arrows, but it's not the arrow you always pull out. If you have somebody harassing somebody, as I said, that's a protection order or a VAPO or one of those things. That's a different tool for a different thing. And you need to look at the situation. As an attorneys, we need to see what is the appropriate tool at this point. And that tool may be a power of attorney. That tool may be the informed consent statute. That tool may be a guardianship and conservatorship.